Well, good afternoon, everyone. Welcome to Minnesota's New Employment Law Provisions, a webinar of Aging Services of Minnesota. My name is Renee McGibbard, and I'll be moderating the webinar this afternoon. In the 2014 session, the Minnesota State Legislature passed a number of laws related to employment that started to go into effect on July 1st. These will impact a wide variety of employees and work settings, and this webinar will explore those laws and what the changes mean for providers of aging services as employers. Now, there's a few housekeeping details I want to mention before we get started here. So first, we need you to email us a list of people who are sitting in on the webinar for your organization and whether they want continuing education credits. And second, we want you to post some questions online as we go along, and I'll make sure to convey those to our presenters. And then finally, I just want to point out that we have a handout that also came with the PowerPoint presentation. We don't often have one of those, so I want to make sure that you don't miss that. And then Rebecca will be touching on that a little bit later and what's available to you from that. So we're going to get started then. I'm happy to say that we actually have two people here today, and one is Rebecca Coffin. She is an associate with the law firm of White, Rohde & Bachseth based here in St. Paul. She practices in the areas of collections, health law, and employment law. She also advises clients on HIPAA compliance and represents a number of nursing homes, home care agencies, and housing with services providers. And with her is Carrie Thurlow. She's a Vice President of Advocacy for Aging Services in Minnesota. Since 2006, she has led the association's advocacy efforts on both state and federal issues and with external audiences. With over a decade of public affairs experience, Carrie came to Aging Services with a strong background in law and public policy. So welcome, Rebecca and Carrie. Thanks so much for being here today.
Thank you, Renee. I'm definitely glad to be here. We've got some important new laws that everyone should be aware of.
Well, I know a lot of us have heard about the minimum wage increase, but there was a lot more that happened at the legislature, isn't it?
Yes, absolutely. We'll touch base on the minimum wage increase, but another new law that has been passed as of July 1st is the Women's Economic Security Act. Kind of a new and important law. Minnesota is one of the only states, or the only state actually, to have some of these laws in place. So a lot of new information, and new information that really directly involves every employer in the state. This first slide here is just an overview of the general information that we'll talk about today. So we can start with the new minimum wage increases. This is a nice little chart that kind of explains the increases. As you may have heard, effective August 1st of this year, the minimum wage is changing in Minnesota. For large employers, it's $8 an hour, and for small employers, it's $6.50 an hour. And we'll get to the definitions and help you better understand if you're large or small. As you can see, though, it does increase progressively in the next few years, and that accounts for inflation by the year 2018. Keep in mind, though, that the federal minimum wage is $7.25, and this could impact what you're actually paying if you're a small or large employer. So a large employer is defined as a business with annual volume of gross sales of $500,000 or more. Keep in mind that this is different. This used to be $625,000, so it has lowered. The threshold has lowered, whether or not you're a large or small employer. And then again, the small employer is a business with annual volume of gross sales less than $500,000. So that chart on the previous slide is really helpful because even if you were a small or large employer previously, you may not be the same right now, or as of August 1st, actually. All right, so the chart also is a good explanation of some other types of wages, types of categories that may affect the minimum wage. There's something that's called a youth wage, which basically an employer can pay to employees under the age of 18. On their 18th birthday, however, they're considered normal, regular employee, and you'd have to go by the regular minimum wage raise. There's also a training wage, which can be applied to the first 90 days of employment for employees under the age of 20. So this may pertain, I know that a lot of you use CNAs or nursing assistants that are either teenage or under 20. This could possibly be applied to them, or really any employee who's under age 20. The summer work travel exemption probably doesn't apply to you, but there is an exception for employers with seasonal workers at hotels, motels, and lodging. So one caveat, or just something to consider, if you're wondering how the heck do we get out of this large employer minimum wage issue and to pay that top dollar amount, don't even think about it. The minimum wage law does prohibit an employer from taking any action to displace an employee. So basically that means, a reduction in hours, wages, or trying to figure out how they're going to get a lower wage. You do not have the right to do that. Also keep in mind that small employers are still subject to review by the federal minimum wage, meaning the federal Department of Labor. And so even if you're a small employer, if you're looking on that chart and you say, oh, I only have to pay $6.50 an hour, that's probably not the case. You are probably subject to the federal minimum wage, which again is $7.25 an hour. And how you figure that out is if you're engaged in interstate commerce, basically a legal term, but more than likely any nursing home, assisted living is going to be subject to the federal minimum wage of $7.25 an hour if you're not a large employer with the $8 an hour in Minnesota. All right, so a little quiz question, which hopefully I've made clear already, but I am a small employer and involved in interstate commerce, so have been paying $7.25 an hour as minimum wage. What do I need to pay on August 1st? Again, the answer is B, $7.25 an hour, so this probably isn't going to change for you as of August 1st. Now also keep in mind, if you look at that chart, each year it increases. So even if you're paying $7.25 an hour for federal law now, if the state law goes above that, you have to pay the higher rate, whether it's the state or federal minimum wage amount. It is possible that the federal minimum wage could change in the next few years. We don't know what's going to happen with that today. But so keep in mind, you always have to be aware of what is the state and federal rate and which one is higher. Again, the minimum wage indexing, it basically means, they're going to look at inflation. That didn't start until January 1st, so the legislature put together specific dollar amounts for the next few years, but they also wanted this to go into the future where they're going to look at, what is the economy doing? So they're going to look at the national implicit price deflator or use the standard 2.5%. The commissioner would also look at, how the economy is doing, and if for some reason you didn't need an increase, if the economy goes downhill again, they'll take that into effect and could possibly have no increase after 2018. All right, so the Women's Economic Security Act, or I guess sometimes called WESA, is, like I said at the beginning, a pretty big deal here. It was signed into law on May 11th of this year. Some of the provisions were effective on that date, on May 11th. The majority of them are either already in effect or because they've also been implemented July 1st of 2014, and then just a couple issues, I think like an unemployment benefit issue that we'll talk about towards the end doesn't start until October. But in general, these are all current laws. So keep in mind that you may have to make some changes both in your handbook and your operations. And that checklist that we provided you is a good summary of who needs to do what, or at least start thinking about doing what as far as making accommodations, making changes in your employee handbook, and training your staff as well. So this is the first statute of its kind passed in the United States, so go Minnesota for being proactive. It amends the Minnesota law concerning pregnancy and how you treat pregnant employees, nursing mothers, parenting leave, and also familial status. The first topic that we'll talk about is wage disclosure protections. Basically, an employer cannot require an employee to keep their wages quiet or a secret. You cannot require non-disclosure of their wages as a condition of employment. You also can't ask an employee to sign a waiver or some other contract or document that would deny the employee the right to disclose their own wages. And you, as the employer, cannot take adverse action against an employee for disclosing their wages or discussing another employee's wages that have been disclosed. So it's one thing to say, you know, Billy, you can't talk about your wages, but if someone else is talking about their wages with Billy, you know, basically any topic about wages you can't do anything about. You can't keep it secret. The other big issue here is that you need to put this information in writing. Probably the best way is if you have an employee handbook to include a provision in there that should this new law be violated by you, the employer, the employee or the ex-employee, if they were fired or terminated, they have a right to bring a civil action against you if you had violated this law. And not only that, but they are entitled to reinstatement, meaning getting their job back pay, and possibly attorney's fees too. So again, this, you know, I think the whole purpose of this law was to not have the wage disparity between different workers, women and men, or, you know, anybody, and have it be open communication. People can talk about how much they're making.
So I have a question about that. So the impetus was sort of fairness, and because people can talk to each other, they can find out what each is getting paid. They go, oh, wait a minute. You're a man, you get paid this. I'm a woman, I get paid this. Something's not right here. So this is actually allowing that to occur in a workplace.
Exactly. You know, I don't know this statistic, but you hear them all the time that, you know, women make X percentage of money compared to a man in several different employment areas. And this law is designed, hopefully, to prevent that or at least lessen that impact.
Yes.
And this is Carrie. I'll just say there was pretty compelling testimony at the Capitol on this particular issue of women that had been terminated because they were discussing their wages and had not only been discussing their wages but found out that they were making less than their male counterparts, and you know, thus creating the impetus then for other pay equity actions. So there was pretty compelling testimony, but it's not just applying to women here. It could be any discussion about wages. So
Yes. Wow.
All right, another thing that we saw change is nursing mother accommodations. So there already was in place before July 1st of this year a law that you have to provide nursing mothers accommodations, but they tweaked a little bit. They made it a little easier for the nursing mothers and basically made the employer's obligation a little bit greater here. So it does expand the current law to provide nursing mothers with reasonable unpaid break time to express breast milk and to make reasonable efforts to provide a room for nursing mothers. So this room cannot be a bathroom or a bathroom stall. It has to be shielded from view and free from intrusion, so you don't want people walking in and saying, oh, I'm just going to the copier or something like that.
That would not be good.
And it also must have an outlet. And again, here, the employees may bring a civil action against the employer for violation and also recover attorney's fees. Now, this law is a little different than some of the other updates from VISA in that the definition of an employer means a person or an entity that employs one or more employees. So my guess is that everyone out there.
So Rebecca, on that point, just a question that I know that has arisen sometimes is, does this have to be designated, how do you designate a nurse, a room? Does it have to be something that's always set aside, or is it just upon need, or do you have any thoughts on that?
Yeah, that's a good question. If your building or your area is large enough to have a designated room with a sign on the door saying, you know, nursing mother room, great. Is that required? Absolutely not. So, you know, a lot of smaller employers will either have an empty office or a specific break room. You know, the requirements are that it has an outlet and that it's free from intrusion. So, you know, for example, would the copier room be an appropriate area? No, because it's probably not free from intrusion. So, you know, if someone even is, you know, out of the office and you know, the room could change. It could be, you know, my office this week. It could be somebody else's office next week. It doesn't have to be a designated room.
Okay, good.
All right, so pregnancy and parental leave has also been changed. This new law requires employers with 21 or more employees to provide up to 12 weeks of unpaid leave for a biological or adoptive parent for the birth or adoption of a child, or a female employee for prenatal care, or one who is incapacitated due to pregnancy, childbirth, or related condition. Now, the big change here is that it used to be 6 weeks of unpaid leave under the Minnesota law. It went up to 12, so it doubled. Pretty big deal here for Minnesota employees. Keep in mind the FMLA, which is the federal law, Family Medical Leave Act, allows up to 12 weeks. But depending on what size your business is, if you're somewhere between that 21 employees and 50, which the FMLA requires, this could significantly impact you today. With paid leave, and that was the next point, paid leave, vacation leave, and leave taken under the federal FMLA may run concurrently. So this law is not saying that you have to give 12 weeks for the Minnesota law and 12 weeks for FMLA. It can be all one and the same 12 weeks. Part of this law, too, is no retaliation, so you can't retaliate against someone who's had a child or who's pregnant, and in other words, you can't demote them or terminate them from employment because they're accessing their rights and using this leave. You may, however, as the employer, have reasonable policies regarding the logistics of the leave. An example is, you know, asking them to provide reasonable notice and communicating the expected duration of the leave. So more than likely, if the woman is pregnant, she's going to have an estimated due date, or at least you know, sometime that she knows that the baby is going to be coming. This may not be possible if it's for pregnancy issues, because you never know what's going to happen during that. But the point is, you kind of have policies in place that says, hey, if you have an idea when you're going to take this leave and how long, please let me know. Please put it in writing. That is totally acceptable.
So Rebecca, I think a question that's come up on this before is on the no retaliation piece. When the employee comes back, would it be considered retaliation if she's given reduced hours or a different shift?
Probably it would. You know, similar to the FMLA, where you're required to put that employee in their same job position with the same benefits and rate. It could certainly be considered retaliation if you're demoting them or giving them different job duties. Absolutely.
Okay, but what about a different shift? So same position, but perhaps maybe not the most desirable shift. Any thoughts on that?
That it may be up to interpretation.
Yeah.
You know, it probably would depend on what your business's needs were. You know, if the individual was gone for 12 weeks and maybe the nursing home beds are down in capacity, or, you know, that daytime shift has been filled up, or whatever their shift that they were working, you know, maybe not, maybe. It's hard to say, probably a case-by-case basis.
Yeah, yeah. Tread carefully.
Yes. All right. The other issue with the pregnancy and parental leave is that the definition of an employee has been changed. It used to be that an employee was an individual who had worked for the employer, for you, for 12 consecutive months immediately preceding the leave. The new statute deletes the, so I should say words, not works, consecutive and immediately. So in other words, if that employee has worked for you for some point for 12 months, they may be eligible for that leave.
What if they'd only been there a month?
Then it wouldn't apply. Then they wouldn't be considered
Right.
an employee or eligible for those benefits. Yep, good question. The pregnancy accommodations are effective immediately, so that meant back when the bill was signed, which is months ago. So you are required to do this now. It requires employers with 21 or more employees to provide reasonable pregnancy accommodations to female employees with health conditions related to pregnancy or childbirth if she requests. Now for this, she does need advice from her healthcare provider or a doula. So we'll get to the next slide that has some accommodations that are deemed already by statute totally reasonable, not an undue hardship. You need to give them no matter what. But the employee may request certain things where you need to sit down with your HR staff, your managers, whoever's in charge of making these decisions and figure out, what is this employee asking and is it an undue hardship? And the term is called the interactive process. Basically, you need to figure out what is this person asking for, what can we offer, and is it a reasonable accommodation? I definitely recommend, documenting that discussion and what considerations you went through to decide if it's reasonable or not. And then let that employee know your decision. And if it's not reasonable, for example, if, she's asking to do absolutely no work, she's not even able to do desk work, or, she physically can't do her job duties by the accommodations that she's asking for. Maybe that is an undue hardship, but again, each case is going to be so different depending on what the person is asking for, what your staffing needs are, what the job requirements are. So there's a lot of factors that you need to be considering when an employee asks for an accommodation. So like I said, some accommodations are deemed by law to not pose an undue hardship. So if a pregnant employee asks for certain things like frequent restroom breaks, more frequent food and water breaks, more seating, or even sitting for the majority of her shift, or limits on lifting over 20 pounds, the statute is saying that these do not pose an undue hardship, and you are required to offer that. Keep in mind, for these specific requirements or accommodations, the employee does not need to consult a healthcare provider. Just the mere fact that she is pregnant and asking for this means that you do have to provide that. Now, this is a big issue for you guys, providers, because my guess is most of your nursing staff and nursing assistants, part of their job duties, part of their written requirements are to lift over 20 pounds. So Carrie and I were chatting about that a little before the webinar started. And some ideas that we have is, look at your staffing. Maybe you can rearrange their shifts. It's possible that you are going to need to hire on a new person to help or cover if it's, the lifting residents, if that's the issue. But you are required to do it, so you're going to have to find a way.
Rebecca, we do have a question here from one of the members, so let me kind of read through this. So for the 12-month requirement, is there a certain look-back period that applies? For example, if someone works here for 5 months, quits for 4 years, comes back for 8 months, quits for 3 years, etc., do we still need to accommodate that? Is there a limit to the look-back period?
Reading the strict language of the statute, no. I would say no. They took out the words consecutive and immediately. So, this is a new law. There hasn't been litigation or case law on it, but the strict words of the statute, no. If they've worked for 12 months at all for you, you'd have to provide that.
Wow. Okay.
I think the other thing to point out about this, as we're still on pregnancy accommodations, I believe it's not on here, but I think there's a no retaliation clause on here too.
Right. I mean, I think most of these new laws here with the employment, they're going to say no retaliation. So again, that means if an employee, a pregnant employee, asks for this more frequent food break or some other accommodation, your response can't be no, and by the way, you're fired. Absolutely not, because there could be definite civil actions against you for any retaliation.
Right, and I think it's kind of an interesting question about no, and we're going to move you to a different shift, or no, we're going to reduce your hours.
Yeah.
To me, that's kind of, again, kind of that fuzzy area.
Right now, the other thing to keep in mind is if they are asking for reduced hours, that's a different story, right? That could be in itself an accommodation. If they're normally working 40 hours and she says, no, I get tired more frequently and I want to stay home more and rest and I only want to work 30 hours, that may be a reasonable accommodation that you could provide. But mandatorily reducing their hours, that could be retaliation.
It's a good distinction.
All right, so the next topic that we're talking about, still within the WISA, the new laws, is they've expanded what sick leave is. This was effective July 1st. It applies to employers that offer a sick leave benefit. So it used to be that an employee could use accrued sick leave to care for the employee's adult child or minor child, spouse, sibling, parent, grandparent, or step-parent. Now they've basically expanded what it is to use their sick leave for family members. So in addition to all those other family members, an employee can use sick leave to care for their mother-in-law, father-in-law, or grandchildren. So, if you get this request and you have to figure out, okay, do we allow this, do we not, look at the law or look again at this slide. And that's not to say that you can't have a sick leave that, allows them to take care of their neighbor. You certainly could. But these are the people that if you are providing a sick leave benefit, you have to allow your employee to take their sick leave to care for these individuals. This is also, I should point out, different from the federal FMLA. That law allows you to take care of family members, but a family member is different. That would be considered a spouse, son, daughter, or parent. And the distinction is different too, because with FMLA, it's a serious health condition which has its own definition. With the Minnesota law, it's a little bit more loose. Basically, if one of these individuals' family members is sick and they want to take their sick leave to care for that person, they can. Employers do have the ability to limit the use of sick leave to care for a covered relative other than minor children up to a maximum of 160 hours in a 12-month period. That, I don't know how often that would even be involved. In 160 hours, I think that's 20 days or something of 8-hour shifts, so that's a long time. If you offer that much sick leave, I want to work for you guys, I guess.
Right. Right. Okay, we're going to do a little poll here. I'm going to try this out for the first time, and we're going to have her ask the question here, and I'm going to pop it up, and you'll see it on your screen near your question area, near the box that you have there in front of you. And I'm going to have you respond, and we're going to see how we're doing so far. We're going to check for understanding. That's the technical training term. Check for understanding. So go ahead.
True or false? The new law for sick leave requires employers to provide paid sick leave.
Okay, the poll is open. Let's see how we do.
Don't look at the next slide.
Yeah, don't look at that. It's cheating. Don't do that. All right, 62% so far. 77% have voted. Very good. Everybody's answering the same thing. Very good. Okay, why don't we wrap it up? What's the answer?
All right, so the answer is false. An employer is not required to provide paid sick leave, but if you do, then this law applies to you and you must expand the use of the sick leave.
Okay, we did have a couple people that answered the wrong answer.
Okay.
By and large, everyone's paying attention, Rebecca.
Pay attention.
Thanks.
All right. In addition to the expanded sick leave and the family members that you can take sick leave for, the Minnesota law has expanded it to include safety leave as part of sick leave. And basically what that means is you can use safety leave for yourself, the employee, or one of those covered relatives if the leave is for the purpose of providing or receiving assistance because of sexual assault, domestic abuse, or stalking. So, this is a new law. There's not a whole lot of interpretation or any on what this means. So you really just do have to look at the language. And if, an employee came to you and said, I'm being stalked or I'm being abused and I need to take, leave for this reason, you do have to allow it. And if you do have that paid sick leave, you would have to pay them for that time.
I would say at the legislature, some of the examples that were given, again, not necessarily binding on the interpretation of this, but some of the examples that were given were court appearances, everything from court appearances to doctor's appointments to finding new residents. So there were fairly broad examples given under when the legislature was considering this as to what would be providing or receiving assistance to those circumstances.
So, maybe when in doubt, approve it, I think would be probably the best way to go if it's anywhere remotely related to one of these issues.
Okay, I have another question here. We don't offer sick leave, but PTO. I'm assuming PTO must be allowed under the same as sick leave.
Right, so there's actually no law requiring an employer to offer PTO either. So I would look at your policy and see, is the PTO strictly for vacation? Does it have anything to do with sick leave? You might want to look at your policy and before making any interpretation of whether or not this applies to you.
Okay, so don't assume that. Okay.
All right, so another big change is that the law included familial status as a protected class. It amended the Human Rights Act, the Minnesota Human Rights Act again, to add familial status as a protected class from discrimination. Just so we're all on the same page, other protected classes are like race, age, disability, there's a whole list of them. But familial status is defined as the condition of one or more minors being domiciled with their parents or the minor's legal guardian or the designee of the parents or guardian with written permission. So a really long definition, but basically saying if the employee has kids living with them, then you can't discriminate. It also protects any person that is pregnant, so they're also considered a protected class under the familial status definition, or if they're in the process of securing legal custody of a minor. So if they're looking to adopt and they're in that process, they're basically treated as having a kid or about to have a child, and they're part of that familial status protected class. So what does that mean in practical terms? It goes back to the discrimination, the retaliation that we've been speaking about. You are prohibited from terminating them solely based on their familial status. You're prohibited from discriminating them, retaliating them, demotions, anything that would lessen their benefits, anything like that would be considered discrimination.
Let me ask you on that minors being domiciled with somebody, so they're living with you, but is there a indication of how you know that person's really living with them? So maybe they're part-time with their dad or, maybe just living there. How's that defined?
Yeah, that is a good question. From my limited knowledge of family law, the domicile, there is definition about who the individual lives with and domiciled with. And it's possible that if the parents are divorced, the child could be considered domiciled with both.
Okay.
So you don't have, I'm not saying you have to ask for their divorce decree. I think, though, that the point is, if you know that this child lives with the parent, even if it's every other weekend, more than likely this employee is going to fall under that class of familial status.
Okay.
This new law, like I said, it is new. It could lead to litigation due to the uncertainty regarding the limits of this new protected status. And Renee, you're right. I mean, even that issue could become, is the child domiciled as far as employment law? Is it different, with respect to family law and employment law? That issue could certainly come up in the future.
I think they should look at where the school district is. They definitely have an address for that child.
I know that the legislation, when they discussed this particular provision at the legislature, part of the discussion or the rationale behind it was this sort of underlying either overtly or inadvertently preventing especially women who have children from seeking promotions because of the idea that they have children and they may not want to have those promotions. I think that was the idea, but I think there were a lot of questions raised at the legislature about the parameters of this. Does this affect, for example, and I'd be curious what you think, benefits, family versus single benefits? Does it affect other sorts of differentiating factors between those with children and without? And I don't know, do you have any thoughts on that?
Yeah, good question. I mean, part of discrimination is discrimination against benefits. So it's the adage, offer it to one, offer it to all, and you aren't allowed to treat anyone any differently. What we hear in my office a lot is people saying, well, this employee has a small child and can't work on weekends because there's no daycare. Well, how do you resolve that? So this person, if your stated policy is that your nursing staff have to work every other weekend, maybe it's possible to do an accommodation, maybe it's not. Again, it's going to be on a situational basis for your particular employer and also that particular person and what the job duties are. Also keep in mind, this isn't just for women, the familial status. It's anybody who has kids living with them or her.
Oh, here's just one more follow-up question on that PTO. I'm sorry, I just spotted this. So it says, did you say that if your company has PTO, the safety leave could also pertain to you or your company?
So the statute is phrased as sick leave. It's not really called just paid time off. So that's where I would say, look at your policy and see what it says. If your policy, your PTO policy, paid time off policy, only allows for paid vacation and has absolutely no other days that you're going to pay people for, then it most likely doesn't apply to you. The statute says this applies if you have a sick leave policy.
Okay, great, thank you.
Yeah, that's fine. And my understanding too is like if it's a very flexible, if you don't have any restrictions on PTO and you can use it for both, that you may kind of fall in that area where that may not apply. But I don't know if you're the expert, I'm not.
Yeah, I mean, I would say, look at your policy, and if you want to revise your policies to make it clear that you're not offering paid sick leave, you can certainly do that. If you don't want to have this safety leave as part of anything that you offer, then you also would need to be very clear that you're not paying anybody for any time that they're sick. And that would be the most clear way, is to change up your policies. Because again, you're not required to do this unless you have that sick leave policy in place. All right, so another part of the new law is pay equity certificates. Employers are required to obtain an equal pay certificate from the Department of Human Rights in order to execute a government contract in excess of $500,000 in order to eliminate sex-based wage inequities. This applies to businesses with at least 40 full-time employees. It does create an undue hardship provision. So again, what that means is if you don't think that you can get this for whatever reason, if your your nursing staff seems to be 99% women, you may or may not, and that's just the area you are in, maybe outstate Minnesota, and the job market is not a lot of males in that area applying for your position. Maybe that is an undue hardship provision. The star here on that slide is it may not apply to most contracts with the state regarding insurance, healthcare, or reimbursement of healthcare services. So, you know, the Medicare, Medicaid, I think that's basically what they're talking about, I guess. I know, Carrie, do you have an example of where this, you know, may apply if they have a state contract?
So we were involved in negotiations with both the exemption language and the language itself. The intent of the exemption language is to exempt out Medicare, Medicaid contracts and other healthcare services. Where I think they're very interested in applying this are for like contractors, road contractors, bonding contractors, construction industry, kind of those areas, some of those kind of other technology contracts that might occur with the state. So we had a long discussion and got agreement with the advocates to exempt out, as you can see, insurance, healthcare, or other healthcare services. However, there may be other contracts that our members have with the state that don't fall into that language. There may be grants or other things that apply that aren't necessarily covered by that language, and it will be subject to interpretation of the Department of Human Rights. But contracts, from the viewpoint of the Commissioner of Human Rights, is very broadly worded, as long as it meets the $500,000 threshold.
So clear as day, right, everybody? All right. One of the other big changes is the unemployment eligibility. So the unemployment law was amended to make it more likely that victims of sexual assault and stalking would qualify for benefits if the applicant quits because of domestic abuse, sexual assault, or stalking of either the unemployment applicant, your ex-employee, or that applicant's immediate family member, if it necessitated the employee's quitting the employment. Applicant here is meaning applicant for unemployment. So basically, you know, in general, the unemployment law says that a person who voluntarily terminates their employment, i.e. quits, is not going to get unemployment. Here they're making it a little looser. They're saying if the reason that they quit was because of domestic abuse, sexual assault, the stalking, then maybe we're going to be a little bit more accommodating and we're going to give that person unemployment. So you can see that, you know, this law and then also the safety leave law, they really, this is one of the big changes that Minnesota is a front runner on here, saying, you know, we're going to protect these people who are victims. You know, how often this is going to come into play, I don't know. Hopefully not a whole lot for your employees. But it is out there, and just keep that in mind. This doesn't become effective till October. This is one of the changes that isn't already in effect, but something definitely to keep in mind for your employees. All right, well, we do have some time left, so, you know, I just want to remind you that you do have that checklist, the handout. What I did in creating this was kind of just put down some of the key points for what you should be considering about your employee handbook if you have one. If you don't have an employee handbook, maybe even, you know, employee policies that you have if they're not formalized in a handbook. But you may want to look into changing the nursing mother accommodations about, you know, their rights for the leaves, the rest periods, the eating, the breaks that they allow for pregnant employees, but for the nursing mothers, the rooms, and just letting them know that, you know, that is available. The pregnancy accommodations and the prenatal leave, again, if you have a policy in place from the Minnesota law, it more than likely does say that 6 weeks, but again, now it's been changed to 12 weeks, so look at that. The sick and safety leave, and, you know, the questions about PTO, just look at those policies, look at them closely, and, you know, this would be a good time, if you don't have one, to create one, and if you do have one, to maybe figure out if it needs any changes. Updating the familial status as a protected class. You probably have some type of statement about, you know, EEOC and, you know, non-discrimination, so definitely update that. And then the wage disclosure, that their right to bring a civil action against you, that is important, again, because that is a requirement that needs to be in writing, whether or not you have a handbook or not. Just some thoughts too for human resources or your manager training. Make sure that they know too about these non-discrimination, retaliation issues. You know, it's one thing to hear it today, but how are you going to disseminate all this information? And you know, if you're the administrator or the HR person, make sure that your managers know too, because a lot of times it's the nursing managers or the floor managers who do have that power to change up shifts or even sometimes hire and fire. So make sure that they are aware of all these new updates as well. And then, you know, the operational issues, the minimum wage changes, obviously that's going to be an ongoing issue with funding and everything, but how, you know, realistically and operationally are you guys going to be able to abide by these new changes? The wage disclosure, again, whoever it be that fires people or sets the rules, make sure that there's no terminating someone because they're talking about how much they owe. And then, you know, the pay equity and unemployment eligibility, whoever is in charge of the unemployment hearings, if you guys do appeal those from time to time, make sure that they are aware too that these employees have new rights under those laws.
We did get a question about the minimum wage. Going back to that one particular slide, she was just wondering if the dates were accurate on that. She did want to verify that. So you've got effective 8/01/2014 on some of these, effective 8/01/2016, and then 2018.
Yep, the middle line, sorry,
the
second line should be 2015. Good catch.
Okay, very good. So why don't you run through that again then with them? So large employers goes to $9 an hour.
August 1st, 2015.
And small employers go to $7.25 an hour on that same day of 2015. Youth wage goes up to $7.25 an hour on August 1st of next year. Training wage $7.25 an hour, and the, what does it say, non-immigrant visa? Ooh.
Right, and that one, you know, that's the issue about the summer work travel employee exemption. Probably not going to apply to you, but in the chart.
Gotcha. All right, thanks. Anything you want to add, Carrie, or anything that came up maybe in those district meetings that we haven't addressed?
No, I think we've raised many of the questions. I mean, I would just encourage folks to really follow the checklist that Rebecca's provided and really think through. There's a lot of scenarios out there that you might think you're doing something right, but this has a lot of intricacies and you have to think through it. And Rebecca's a great resource, as are others if there are questions, I'm sure.
Well, very good. And I don't see any more questions posed here. So why don't we wrap it up a little early so people can get out and maybe get a little sun. So I really want to thank Rebecca, you know, and you, Carrie. Thanks so much for being here and providing such great information to everyone. I also want to just plug a couple upcoming webinars before we go here. So the first one is July 31st, and it's Managing and Working with Difficult Employees. That's in the morning, and that will bring back Rebecca and her colleague Rob Rohde. And then on August 12th, Jerry Kerber of the Department of Human Services will discuss the new fingerprint requirement for background studies. And you can learn more about these webinars on the Education and Events page of our website. And once again, remember to email us. No, I shouldn't say that. You want to mail us the list of who was sitting in on the webinar for your organization today. And then please watch for the post-test. It'll come to you within the next 24 hours. And you must complete the test and pass it to get your continuing ed credits. And with that post-test is an evaluation of the webinar, and we really do value your feedback on that, so please complete that. Well, thanks so much, everyone, for being here and really for all the great work that you do, and enjoy your afternoon.
Thank you.